My name is Michael Blue of the Blue Law Group. We have offices in Los Angeles as well as Rancho Cucamonga, serving the needs of clients from San Bernardino and Riverside counties to Los Angeles and Orange counties. Now today's topic is about taxation, in particular the differences between the C corporations and the S corporations. Now my background is I'm not only an attorney, but I'm also a certified public accountant and have a tremendous amount of expertise in taxation and business formation. Now, a C corporation is an entity where you organize as a corporation under state law and the laws of the state of California. And what it is it is an entity that has limited liability, which is extremely important, yet has a double taxation. And that is the big issue with C corporations. One way to get around that, and many people try to get around that, is either through either staying as a sole proprietor, meaning you're just selling your goods and services basically as yourself without really an organization, or engaging in a partnership, or engaging in a limited liability company, or a limited partnership, or a limited liability partnership, or an S corporation. The S corporation, and this is our particular focus today, is a sort of an entity that has the limited liability of the C corporation, but only has single taxation. What do I mean by limited liability? What I mean is that you, as the owner, put a certain amount of money and assets into that corporation, and a plaintiff in a lawsuit will essentially only be able to sue that corporation for its assets, essentially limiting the liability at the corporation and not overflowing into your own personal assets. Now, there are exceptions to that rule that are beyond the scope of this conversation, but notwithstanding those exceptions, that is the prime goal and the prime target and the prime benefit of a C corporation. Now, the problem is that corporation, being treated as its own entity, will have a taxation on its profits. And once those profits are taxed, the net of those profits are distributed through dividends and returns of capital that, again, are beyond the scope of this discussion. But essentially, those distributions will go to the shareholder as income, and that income will be taxed, barring and not subject to exceptions, which are beyond the scope of this presentation. So you are going to get taxed with the income that you get from the corporation, and the corporation itself will be taxed on the profits that it has. So by the time it gets to you and you pay, it has been taxed twice, at the corporate level and at your single level. Now, the S corporation, by contrast, it exactly does, it keeps the benefit of the C corporation in terms of limited liability, meaning that barring exceptions, you're not going to get sued for your personal assets, and only the assets of the corporation will be at stake from a plaintiff's lawsuit. However, the S corporation, the major cost of a C corporation is that double taxation. And under the S corporation chapter of the tax code, it only has single taxation, meaning that the profits from the S corporation are not taxed, and those profits flow to you as the shareholder, and you are taxed only at the shareholder level and not at the corporate level. It is a very, very strong benefit. You get the benefit of the limited liability without the cost of the double taxation. And that creates a whole litany of potential tax planning areas where you can use to limit those taxes that you pay, and keeping the bulk of the money, maximizing the money that you keep. Remember, it has been a long-standing rule under the federal tax code that was really sorted out in the federal tax courts, that it is not against the law to avoid tax. Tax avoidance is fine. Tax evasion is different, and that's violating laws and breaking laws to cheat and defraud the government from its rightful tax. But tax planning and doing the things that you need to do to limit those tax within the law are completely fine. That's tax avoidance, not tax evasion. Now, specifically, there are certain things that you are going to encounter in this S corporation and C corporation, and what I'm going to do for the remainder of this discussion is really hone in on some of the shareholder issues. Aside from whether you choose a C corporation or an S corporation, we're going to hone in a little bit on the shareholders. One thing I will add before I move into the shareholder issues is keep in mind that a C corporation, there are different incentives as well. You can sort of create a single taxation to a C corporation by increasing the wages, all the profits, and increasing the wages to absorb all those profits, and therefore there are no profits in the C corporation to be taxed. Now, the IRS is aware of these things, and if there are unreasonable wages, the IRS may come in and audit you and reclass some of those exorbitant wages as profits and tax those profits, and of course there will be penalties applied subsequent to this reclassification. Now, the S corporation doesn't have that problem trying to bleed out profits through high wages, so the S incentive is to actually reduce wages as much as possible so they don't have to pay the Social Security and Medicare tax that are part of wages. And what that does is the IRS is well aware of that as well, and so they will move in and audit an S Corp shareholder and may reclass wages that are too small, unreasonably low, increase those wages, apply Social Security and Medicare tax and penalties as well. So you've got to know what you're doing, whether it be a C or S, or in some cases an LLC and LLP, a partnership. But again, those are beyond the scope of our discussion here. Now, moving in to shareholder issues. Lots of people go in and create an S corporation or create a C corporation, and they don't have an agreement with the other shareholders. They're happy, they're all on the same page. It's not uncommon to have 5 shareholders or friends. They believe in the product, and there's no need for an agreement. Ladies and gentlemen, this is exactly where you start getting into problems. It's a very, very severe problem, because I have been on the other end of that 5-10 years later, when the 5 people cannot get along anymore and they paralyze a company, and in some cases make a multi-million-dollar company absolutely worthless because they're retaliating against each other, and they are doing all the things they can do to inhibit the growth of this company because their personal vendettas subordinate the goals of the company. So how do we get around that? Primarily, ladies and gentlemen, is to create a shareholder agreement in conjunction with bylaws of the corporation, and make sure that the expectations of each of those shareholders are fully spelled out. The more you can spell those out, the less ambiguity, the less uncertainty. Everyone will know each other's roles, and if they're not meeting those roles, everyone will know it, including the person and or people not meeting those roles. So what does that mean? It means, as another provision, you're going to want to have a buyout provision. You are going to want to spell that out very expressly, and that can take form in all sorts of different manners. Often you might see a buyout provision saying that if 67% of the shareholders or the shareholder votes don't like this other shareholder, that vote can buy you out. And you are going to want to have not only a shareholder number, whether it be 70% or 55% or 80%. Typically, you're going to want a super majority. You're not going to want to be able to vote somebody out on 51%. You're going to want a super majority. You're going to want it to be an extreme amount of the majority of those shareholder votes saying, we don't like this person. 51% is too volatile. You can get a 51% much easier than you can get a 67 or 70 or an 80%. And you want it to be difficult, but not impossible. And so you would want a percentage, say a 67 or 70%. And once you have that 70%, you can vote that person out, force that person to sell the shares back to the corporation under this rule. And the second thing you're going to want to have with respect to this provision is a particular mechanism, a mathematical mechanism to show how much this person must sell their shares back. When companies are small, when they're what they're called closely held corporations, meaning 5 or fewer shareholders owning 51% or more of the 51% or more of the voting power of the shares, you have a closely held corporation. And what that means is that there is not likely going to be a market for these shares. And so what does that mean? That means that you have to create a value for these shares. And that can be done in all sorts of ways, from the corporation need only return the original investment, to things like mechanisms like 30% of the profits from 3 years ago, to 35% 2 years ago, to 40% this last year. You combine those numbers, and that's what the value of those shares are. There's no right way to do it. But you do want a percentage share, and you do want a mathematical mechanism. Additionally, if you have 2 shareholders, a lot of corporations, they come to us and they have 2 partners, 2 friends, and they want 50-50. They want 50 shares and 50 shares. And the first thing we do is say, you are going to paralyze this company on 50-50. It is the exact wrong thing to do. Because on 50%, if these 2 partners, if these 2 shareholders become angry at each other, they have the perfect shield against each other. 50% is a shield. It means you can block everything. And so if they're both blocking everything, you're going to get nothing done. You're going to paralyze this corporation. So having 50-50 is a very, very bad idea. You're going to want at least to have 51-49. And that means whoever has 51% has a shield to block the other person and has a sword, and they can do whatever they want to do and be unchecked. That is the way that you're going to want to set this up. So you're going to be very, very careful on how you do 51-49, but that is going to at least stop the paralysis of a corporation, that a corporation will move forward, even if the 2 shareholders are angry at each other. Now, another issue that comes up is having those original, say, 5 shareholders and keeping them in the company. What's to stop them from getting 20%, 20%, 20%, 20%, and 20%, and 3 of those people leaving? Okay, you just lost 60% of your shares. You still got to pay them 60% of the profits, essentially, but they're gone. They are no longer there. And if you don't have a shareholder agreement or bylaws that force them to work, you're going to be in a difficult position, especially if you've now got to create more shares or somehow run this company by yourself. What do? One of the ways to get around that is to vest the shares. So not everyone gets 20%, 5 shareholders all get 20% on day one. You get shares slowly over a period of time, that they, that maybe over 5 years you're getting 20% total. You get 4% per year for 5 years, and after 5 years you have all 20%. And what you can do is you can vest them at the end of a year, for example. So you get 4% per year, but you only get it if you are employed as of the end of the year. That forces your friends who are part of the makeup of this corporation to stay in the corporation. And finally, the last thing I'll discuss very briefly is understand that if you ever sell your shares or sell this corporation, there are going to be tax planning opportunities to alternate between what are capital gains at a lower 20% tax rate, or ordinary gains, which are going to be taxed at your income level. And if you're making a lot of income, that could reach as high as close to 40% just on the federal side, and almost another 10% on the state side. So you could be looking at close to 50% tax if it's taxed as ordinary gain, meaning you're selling, for example, assets, versus selling your stock and liquidating your entire stock, which is going to give you the best chance to get a capital gain. The gain will be the same, but if you're taxed at 50 versus 20 to 30%, that's going to be the difference, and you're going to want to know how to maneuver between an ordinary gain and a capital gain. Ladies and gentlemen, Michael Blue, the Blue Law Group, tax expertise, both a lawyer and a CPA. I've handled these things, these types of clientele, these types of situations for many, many years. come and see us. Blue Law Group with offices in Los Angeles as well as Rancho Cucamonga, serving the needs of clients from San Bernardino, Riverside counties to Los Angeles and Orange counties. Thank you.